Testing, 1, 2, 3, 4. Testing, 1, 2. Number 8. Testing, 1, 2, 1, 2, 3. Testing, testing. 1, 2, 1, 2. Changed already. Just tap on the screen one time and you can see whoever's speaking. Testing, 1, 2. There you go.
Good morning, everyone. Okay, we're getting close to time before we're going to go ahead and start our meeting. I'm going to give our IT folks a few minutes to get everything set up, and then we'll go ahead and call the meeting to order. Thank you. Okay, good morning. Welcome, everyone. This is our second hearing of the Peace Officer Standards Accountability Advisory Board. Today, before we get into the first order of business, I'm just going to make a quick announcement about the proceedings today. As many of you know, on the board, Ms. Dudley, our chair, will not be joining us today. Sadly, she would have been here if she could, but due to some unforeseen circumstances, she will not be joining us today. So I will go ahead and facilitate at least the first half of the meeting until we get to our cases that are before the board today. And then we will probably have our vice chair, as long as that person feels comfortable, facilitate the remainder of the meeting. Does that sound fair to the board members? Okay, great. All right, I'm going to go ahead and ask Chandler to call the roll this morning.
Okay, good morning, members of the board. Board Member Bushin. Board Member Clavo.
Present.
Board Member Crawford.
Present.
Board Member Doyle.
Here.
Board Member Dudley. Board Member Glaser.
Here.
Board Member Johnson.
Present.
Board Member Lara.
Here.
And Board Member Pena.
Here.
Okay, thank you. So we have a quorum. I want to thank those of you who are in attendance today. We want to take a couple of notes to kind of explain to you that this meeting or hearing is being webcast. It's also being recorded and transcribed. The microphones are on auto on and off, so you do not have to touch them before you speak. As soon as you begin speaking, they will go live. When you're not speaking, they will not be live. You will need to watch the crosstalk, because if you lean over and talk to your partner, that'll be caught on recording and webcast, so just be advised. I also want to thank those in attendance today for joining us. When you are asked to come forward for public comment, you may introduce yourself and your association. You do not have to, so that is voluntary. I want to make sure that's clear today. I'd like to introduce some of the folks here at the table today. To my left, I'd like to introduce Chris Beatty. He's our board counsel. I'm Assistant Executive Director Anne Marie Del Manayo of the Peace Officer Standards and Accountability Division. To my right is Chandler Knapp. He works in EXO. Thank you. Okay, we're going to see if there's any public comment before the board today. This is the time that's set aside for members of the public who wish to comment on items that are not on the agenda, but those within the board's jurisdiction. Public comment on matters on the agenda will be heard after each item presented. Public comment specific to peace officer revocation cases to be heard today will be heard at the time of the hearing of each case. Please be advised that the board cannot take action on items not on the agenda, but only to the extent necessary to determine whether they should be made an agenda item at a future board meeting, or to respond briefly to the statements or questions posed, request clarification, or refer the item to staff. Please remember that this meeting again is being transcribed, so I may politely interrupt and ask you to repeat or speak slowly and clearly so that the comment can be correctly captured in the transcript. I may ask members of the public to limit their remarks to no more than 3 minutes pursuant to existing board policy. I also may conclude public comment if multiple speakers are voicing repetitive or similar statements and our 15-minute public comment period has expired. Is there anyone present today in the audience or appearing remotely by phone who would like to address the board during the public comment? When it is your turn, you may state your name and organization only if you wish. Are there any public comments this morning? Okay, seeing none, we'll move on. At this time, I want to take a couple of minutes to do an administrative update for the board members. Again, this is a standing item that will appear on every board meeting, and it is simply to give the board members and members present today an idea of kind of where we are organizationally as a division, and also the volume of cases that we are currently managing. I believe we have a visual for you. Okay, go ahead and go to the first page. All right, this is just an overview of where we are with the staffing for the division. We currently have about 13 full-time permanent law enforcement consultants that are working the cases, in addition to 14 retired annuitants that are law enforcement consultants as well. We're in the process of bringing on a couple of more. As you folks are aware, we did the in-person training on February 13th for the board and the commission. We've also had our staff attend, especially our law enforcement consultants and our division leaders and bureau chiefs, specialized regulatory investigator training. And that was really specific to administrative cases, what needs to be included in the investigation, how the report should be written, and how, of course, you substantiate your findings and report your findings to an advisory board or a governance board. Chief Counsel Toby Darden and I actually did some training for our administrative law judges from the Office of Administrative Hearings. We did that on March 14th. And that was essentially to give those judges that will be assigned the cases when they get to that administrative review an overview of all things Senate Bill 2, the decertification process, the procedures, the types of cases they may see, and a little bit of insight into what we're finding in terms of the cases that are being submitted by law enforcement agencies. We sent out 6 notices of intent to revoke in mid-January. That resulted in the 4 appeals that are before you today. Since then, we've also sent out an additional notice of intent to revoke, and we have not received an appeal back. So as you folks know, we have a May hearing scheduled. Depending on whether or not we get additional appeals from those notices will obviously indicate whether or not we're going to have a May hearing. So I need to keep you apprised as to whether or not we have additional cases for May, or with whether or not our next hearing will be held in June, and we can kind of talk about that later. Next page. Okay, there's a couple of internal improvements that we've made, and one most significant is sending out the notice of investigation to subject peace officers. I think we talked about this a little bit during training, but what that has resulted in is an uptick in our voluntary surrenders. And so we're notifying the officers that post has received a sustained finding from a law enforcement agency regarding one of the 9 acts of serious misconduct. This is upon initial screening. So this is not where post has made any decisions about the veracity of the case in terms of bringing it before the board or the commission. We notify the officers that we are now investigating the case and what the sustained findings were by the law enforcement agency that submitted the case to post. Since January, we've received, and I think this number has changed since I wrote this, it's 11 voluntary surrenders. Prior to January, we might have had 4 or 5. So within the last 2 months, we've really seen an uptick in those based on that notice. We are also working on what we call disciplinary guidelines. Those are almost like what folks would consider a bail schedule in terms of what type of discipline may result in certain penalties. And it's based on obviously the severity of the act itself. It's based on the history of the officer and several other factors. But these disciplinary guidelines will be used to apply some level of consistency to the types of cases we see. They will also give instruction to administrative law judges regarding the imposition of discipline the commission feels is appropriate based on, the facts of the case. So we will be bringing those to the board once they're reviewed by the commission and we get some feedback from the commission. So if you folks can weigh in as well on those disciplinary guidelines. We hope to share those with the commission in June. at their June 13th meeting. Right now, I want to take an opportunity to show you a really short video clip. This is a production that our team in the Learning and Training Resources Bureau put together for the field. And these are officers that are currently in the field, working peace officers. And really, it's an overview of what certification and decertification looks like after the implementation of Senate Bill 2. It's to provide some guidance and more factual information to the line staff who may not have ever had post inform them about Senate Bill 2 and all things certification and decertification. The actual video itself is 7 segments. It's about 43 minutes long, but we're going to show you a promo today so you can see the type of information. You will see there's a couple of us that are in the video. Ms. Clavo assisted in the video when we filmed the production of this, and we think it's turned out really well. We actually contract with a producing company who does all of the staging, you know, puts together all of the lights, camera, action. So it doesn't look like a novice has done this. So I'm going to go ahead and have our team cue this up for you.
A new law has been passed in California establishing a decertification process for peace officers. As a former officer and a current trainer, I've seen firsthand the uncertainty and apprehension this law has sparked among the people I know and work with.
Regardless of how well you try to handle a call, there are times where complaints come through. That is unnerving when you're out working.
You're like, okay, I'm not gonna go out and look for things or pull over cars just in case, like, what if we make a mistake? Because we're human at the end of the day. And then we're gonna be held not only through IA, we have to worry about post clearing us as well.
In this series, we will unravel the complexities and real-world implications through discussions with stakeholders looking at it from multiple viewpoints.
We are now no longer passengers in this journey. We now must take more of an active role.
We had some of the same concerns when we first started using body-worn cameras. Most of the time, the camera has supported the actions of the officers. And so if they're aware of what those areas of misconduct are, they don't really have anything to worry about.
The process is there for a reason. It's there to ensure that your rights are protected. And if you're doing everything right, you're going to come out on top.
In a conversation with officers from across the state alongside post staff, members of law enforcement voice their concerns and search for answers from those who know.
There's questions as to what's going to qualify as serious misconduct. And I mean, can that change from reviewer to reviewer?
I've never seen like a hard definition as to what they're looking for.
That could cause a lot of stress and anxiety. Is there a definition of serious misconduct?
There is a definition of serious misconduct. Part of post responsibility, actually the post commission's responsibility, was to adopt a definition of serious misconduct.
We drill into the details through one-on-one interviews with post experts who are working these cases.
Passing SB 2 was another piece that personally now affects them. And I think that they all need to know what steps and what processes post is taking when we look at cases that are submitted. I think it's important for them to know that.
We're taking the case as it is, and we look at the underlying behavior, and we are stridently neutral. It helps the communities to have some voice into the process. I think it's one of the strengths that gives Post its ability to be trusted in moving these cases forward.
Engaging directly with Post executives and board members, we hear their perspective on how they think this legislation came about and what they have done to prepare for the impact this has on both law enforcement and the community.
Your hairstylist can lose their license, a doctor, a lawyer. When it finally dawned on somebody that there was no way to decertify a peace officer, that was kind of mind-blowing.
I think that's what the community is looking at, is that they're being held to the same standards. They don't want to see them being able to lose their job here, but then be hired at another agency.
It's about integrity. It's integrity in the profession and integrity in the process. Trust in the fact that we understand we're dealing with individual lives and livelihood.
The changes in certification and decertification have illuminated more than just a procedural shift. This journey is not just about a new law, it's about re-examining our commitment to the community, law enforcement, and each other. Watch this Post On Scene investigative series now.
So that's just kind of a promo or a preview to what the full video will look like. And again, that's intended to roll out to the field. We anticipate making that a required continuing professional training for law enforcement officers in the future. Right now, we're going to roll it out and we're going to have them pilot this in, the law enforcement agencies. We're also working on an academy video that will explain certification, decertification for recruits that are in the academy so that before they ever start their career, they have a fair understanding of their relationship with post, which has changed substantially since the implementation of Senate Bill 2. Any questions about the video or comments before I move on?
Video already up on the portal?
No, not yet. We're getting ready to release it. We want to make sure that the commission and the board we were able to show you the promo. Anything else? Okay. Okay, next page, please. All right, this is just a kind of an overview of our current statistics within the Professional Conduct Bureau. So again, just to explain, agency misconduct reports, there's a lot of them. There's over 22,000 agency misconduct reports. Those aren't necessarily cases. Those are reports that have come in. Sometimes there's multiple reports about one incident. But I think what's notable here is 69% of those are retroactive cases. So those date back from January 1st, 2020 to January 1st, 2023. One statistic that we've been asked to include is how many officers are involved in these cases. So here you'll see this 14,940 officers. 550 of those came from public complaints, not from law enforcement agencies. Another extremely notable statistic here is upon initial screening, a small number of these cases actually result in a substantiated finding or a finding of serious misconduct by clear and convincing evidence. And so to put this into perspective, right now we're looking at probably 8% of those cases may, after thorough review, result in some sort of proceeding. And that again tells a different story, right? 22,000 is a huge volume of cases. But when you look at the actual number of cases that we consider meritorious at this point based on what was submitted, we're looking at about 8%. There are 10,327 cases that are opened. Again, you'll see here, about 5,500 are open with posts. The others are opened with the law enforcement agencies, meaning we received them as a complaint charge or allegation, and they're still completing their internal affairs investigation. So it's not complete at the law enforcement agency level. We've closed about 5,200 cases, 5,300 cases, which is 34% of that total number of 10,000 cases, or excuse me, 15,000 cases. Many of those cases are the retro non-actionable. So they did not fall within one of the three categories that we could take action, which is use of deadly force resulting in serious bodily injury or death, dishonesty, or sexual assault. Those were the only three acts of serious misconduct that we could take action on prior to January 1st, 2023. So majority of those cases fall into the other categories. And then again, the top three areas of alleged misconduct is excessive use of force, demonstrating bias, and abuse of power. Any questions from the board on the statistics? Yeah.
What is the percentage of cases that don't apply to SB2? I know at one time.
Non-jurisdictional?
Yes.
Very few. We do have a percentage of those cases. I don't have the stat in front of me, but I can bring that to the board at the next hearing. The reason I know it's very few is we just prepared a report to the legislature, and it's an annual report. In Penal Code Section 13512, the legislation spells out an annual report with various statistics that will need to be submitted every year. One of those statistics is kind of the disposition of the cases from the law enforcement agency submission. So what happened, right? Was it exonerated, unfounded, sustained, or upon review, did we send it back because it was a non-jurisdictional case? So there's a small percentage that we receive that just don't fall into one of the 9 acts of serious misconduct. What we see more of are cases where I think the agencies are attempting to maybe shoehorn them into one of the 9 categories, but it's a failure to act, a failure to supervise, a dishonesty case that doesn't meet the very specific definition in SB2. So the agency may label it dishonesty, which upon initial review is one of the 9 acts of serious misconduct. But if you look at the dishonesty definition, it's very narrow. And so the type of dishonesty that's submitted may be non-jurisdictional. So we do get those cases. And I can bring that statistic back. Any other questions?
I just have a clarification.
Sure.
On the second big bullet point there, the context one, when it says after triage around 5% appear to have potential merit for decertification, is that 5% of those that have passed through triage or 5% of the total?
So the triage, that's 5% of the total after triage, right? So triage is essentially not, we don't like it or we like it. Triage is, these are sustained findings. Which of these sustained findings are going to move, do we think are going to move forward for a thorough investigation and potentially a hearing before the board and the commission? Yeah.
And the 5% is among those.
Right. Correct.
Okay, so it's getting smaller and smaller.
Right.
Okay,
Right.
thank you.
Thank you for clarification. All right. Are there any comments from the public regarding the report? Yeah. On to the next item. Okay, so as you know, at our very first hearing on December 14th, the board took a look at 2 specific cases. Both cases involved acts that violate the law, very different cases. And I'm sure as you recall, the decision of this board was revocation on both counts. The commission reviewed both cases on March 7th at their commission meeting. In the matter of the Ramirez case, the commission upheld the revocation. That was the Justin Raymond Ramirez case, post case number 23-08479. So the commission agreed with the recommendation of the board and moved the case for revocation. So that case will now, if the individual is interested in appealing, would go to an administrative hearing, a full evidentiary hearing before an administrative law judge. So there will be an accusation filed. We work with the Department of Justice and their licensing section to file the accusation on behalf of Post. The individual will be given a 10-day notice of defense to file in response to that accusation. If the individual does not file a notice of defense, the revocation will be the default order, and we will advise you accordingly. In the matter of James Kurtz Fillmore, post case number 2303691, the commission voted to adopt settlement terms. Those terms have not been ironed out to this date. The division is working with our attorney, Chris Beatty, who is also the attorney for the commission and all of the case matters before the commission. We will be presenting what we think they would like to see in terms of settlement terms at their June meeting. And if those settlement terms are adopted, I will report back to the board what those settlement terms are. If their legal counsel does not agree to those settlement terms, the default in that case or the alternative would be revocation. So there's more to come on the Fillmore case. Is there any questions?
Hey, anything more about that? I know there are probably limits to what you can say, but what kind of settlement might we be talking about?
So because the commission hasn't agreed to those terms, I can't publicly describe the nature of those terms. I can tell you that part of the discussion is the division's ability to operationalize those terms. So as you folks may know or may not know, and I'll describe it here for you today, we don't have a probationary unit. So there's not a workforce here at Post that is designed to monitor someone's compliance with settlement terms. So there's some discussion on the operational side of things is how will we monitor any settlement terms that come before the board or commission, even into the future. And we're working those things out right now. Until such time that I can give you a confirmation, I can't say much. I apologize. Yes. Board Member Pena.
Echo, the
Yeah.
sound, there's an echo and it's a little hard to hear every now and then.
If I stay away from the mic, does that help?
Bouncing off the walls and then.
Oh, okay. I'll try to sit back. Maybe it's me. It's possible.
Thank you.
You're welcome. Any comments, public comments regarding the cases that have been heard before the board and now the commission? Okay, seeing none, we will move on. Okay, it is now time for us to decide on the nomination of a vice chair for the Peace Officer Standards Accountability Advisory Board. As most of you know who've served on governance boards, the vice chair's job and responsibilities may vary. For the most part, they're here to sit in for and substitute for the chair in the chair's absence. A vice chair may also be assigned such duties as overseeing a task force or a subcommittee of the board for very specific purposes that the board may delegate to a subcommittee, whether that be audit functions, research, etc. So at this point, is there anyone present who would like to, well, I should say, are there any nominations for the vice chair? Board Member Pena.
I just want to make a comment before we nominate, before there are nominations, that I really personally feel that the vice chair should be someone from the non-law enforcement side of the board. I think the legislature made this board balanced, and I think that balance should be reflected in the chair and vice chair. Thank you.
Any other comments? Okay. Nominations.
I would like to nominate Mr. Robert Doyle.
Mr. Doyle, do you accept that nomination?
For what?
Accept that nomination? Okay. Others? Ms. Pena.
I nominate Regina Hatcher Crawford.
Crawford, do you accept that nomination?
Yes, I do.
Okay. Do I have any others?
I'd like to nominate Nicole Clavo.
Slavo, do you accept that nomination?
I'll pass.
Okay, thank you.
Thank you, sir.
Any further nominations?
I'd like to nominate Board Member Johnson.
Okay. Mr. Johnson, do you accept that nomination?
I'd like to pass also.
Okay. Good news is you all seem to like each other, so that's helpful. Do I have any additional nominations? Okay. So I'm going to take these in order as they were called. I think our first nomination was Mr. Doyle. Do I have a motion to elect Robert Doyle as Vice Chair of the Peace Officer Standards Accountability Advisory Board? You can make a motion, yes.
I make a motion.
Okay. Clavo moved. Do I have a second? Thank you, Mr. Johnson. Hey, Mr. Knapp, will you call the roll?
Yes. Okay. Board Member Buchan. Board Member Clavo.
Aye.
Board Member Crawford.
Nay.
What? Yeah.
Yeah,
Abstain or nay?
nay.
Okay.
Board Member Dudley. Board Member Glazer. Board Member Johnson.
Yes.
Board Member Lara,
Aye.
Board Member Pena,
Abstain.
Board Member Doyle.
Okay, so we have 4 yeses. I think we have 2 nos and 1 abstention. So I believe that motion passes, 7 members present. Okay, so Mr. Doyle, congratulations. You are the vice chair of the Peace Officer Standards Accountability Advisory Board. The reason we don't call the second and third is because we had a motion that passed. Okay, thank you very much. All right, so we are now going to move, I'm sorry, is there any members of the public that wish to comment on this matter? Oh, we have caller on the line. Standards accountability. Reason we don't call the second and third. Go ahead, caller. Did you have a public comment?
I'm waiting for the David Hubbard agenda.
Oh, okay. We're going to take that up shortly in the cases. So we're not quite there yet, but thank you. Any other comments, board, public? Okay, what I'd like to do now, because that completes kind of the administrative business of the hearing today, before we move into the cases, is we are going to take a quick 10-minute break. The vice chair. Oh, I'm sorry. I'm missing something. I apologize. I'm getting ahead of myself. I'm anxious to get to the cases clearly. We need to review the transcripts from the last meeting. So let's do that order of business first, and then we'll take our break. Okay, so at this time, we'll go ahead and take an approval of the meeting minutes from the December 13th, 2023 meeting and the meeting transcript from the December 14th, 2023 board hearing. Any discussion before we have a motion on either set of transcripts? Okay. Does anyone have a motion to accept both the December 13th, 2023 minutes and the minutes from the December 14th hearing?
Motion to accept.
Thank you. Laura? Second?
Second, Doyle.
Doyle? Thank you. Okay. Public comment on the transcripts or minutes from the 2 dates? Okay, seeing none, Mr. Knapp, can you call the roll?
Board Member Buchan, Board Member Clavo,
Yes.
Board Member Crawford,
Yes.
Board Member Doyle,
Yes.
Board Member Dudley, Board Member Glacier,
Yes.
Board Member Johnson,
Yes.
Board Member Lara,
Yes.
and Board Member Pena.
Yes.
Motion carries. Thank you very much. Now we will take a 10-minute break. And we will have our vice chair take over facilitating the meeting for our cases. Okay, so we will reconvene at 9:45. Thank you. call us back to order. We're a little behind here. Good. Okay, we are back on the record. Okay, now is the time of the agenda where we're going to hear new cases that are before the board to discuss whether or not decertification or some form of suspension is appropriate in these cases. I'm going to read some introductory statements before I turn it over to Vice Chair Doyle to introduce our cases. We have 4 cases to hear today. We will only be reviewing the facts and evidence as presented by this division. This is not an evidentiary hearing. The rules of evidence do not apply here. Evidence is not formally admitted into the record. There is no need to make any objections, and objections will not be ruled upon. Under the Penal Code and applicable state regulations, this initial hearing will determine only if the matter will proceed forward for commission review, and then, should the commission approve, for a full evidentiary hearing before an administrative law judge to determine whether the allegations are true and justify discipline. For those commenting on each item, at this early stage, the board must only consider the facts the division, after investigation, believes can be proven at a later evidentiary hearing. For that reason, today the board will entertain arguments as to whether or not those facts, as presented by the division, demonstrate a high probability that serious misconduct as defined in Penal Code Section 13510.8 and Regulation 1205 have occurred. This finding results in the matter being moved forward. No actions by the board or the commission prior to the full evidentiary hearing amount to a final determination that the officer did in fact engage in serious